week. This is a great place for you to start when you're looking at the market, overall market. You know, I have logged into MLS, so every morning I take a look at that market watch and I just get an overall view of the market. New listings 1,002 sold, less than new listings. Pending, about the same as new listings, but look at price decreases. So we had almost 1,200 price decreases in addition to 1,000 new listings in the last 7 days in our MLS. So what that tells you is that we're adding a lot more inventory, and you can consider a price decrease almost as a new listing because it's being repositioned. So we're adding a lot more inventory than we're taking out. So the market continues to grow in opportunities. Although this doesn't count as a new listing, it really in effect works as a new listing. So keep your eye on the market. You can always go in, as we talk about every week, you can always go in and customize this for a particular area, a particular type of home in a particular area. So if you're working with a seller and you want to let the seller know what's going on in their particular neighborhood. Okay. So last week we published the market stats, and let's take a look at a couple of those real quick. Let's see. Let's look at Collier. So we can take a look at what's starting to happen year over year here, and clearly median prices are stabilizing. We're not seeing the big rates of increase that we saw, you know, for the past few months. So now we're comparing really March, which was kind of a peak month in 2022 to 2023. So we're still seeing an increase in the days on market, a little decrease in new listings, pendings down a little bit, and sales down a little bit. So what's happening is inventory is continuing to build and sales are continuing to lag behind last year. So what happens to an absorption rate that was close to 100 a year ago, we're operating at about a third of that. Absorption is the rate at which properties that are available for sale are selling. So a 33% absorption rate means 1/3 of the homes available for sale will sell in a given 30-day period. So if you're working with your seller to figure out what the pricing is, make sure you understand the absorption in that neighborhood.
The 30-day period is key.
Pardon?
The 30-day period is key. The time frame is important to include when you make that comment. Thank you.
We're comparing month over month data, but the easy way to calculate absorption is to take a look at the available homes for sale and divide the homes sold in the last 30, 60, and 30 days for 30-day absorption. You're dividing the number of sold homes into the number of available homes for sale. So overall in Collier, about 1/3 of the homes that were available for sale sold in a 30-day period. So we're looking at 30-day increments when we look at these data. All right, but there's good news in that if I look at the trends, for the last go back. Now let me reshare that. I wanted to look at the trends in what happened there. 1 second. Oh, I don't know how I managed that, but it wasn't easy. All right, let me get the trends back up again. 1 second, sorry. Through the magic of sharing. Somehow I've shared the wrong. There we go. Sorry about that. Let me share. Now what's going on here? Look at this. My share is not working very well here. Yeah. All right, I don't see what I'm doing here. Very interesting here. Let's see if I can get rid of some of these here. Why? There we go. Wow. All right, so if I take a look here, a reason I wanted to work a little bit harder on this is because what I want you to notice is in the last 15 months, we've tracked the light green is homes for sale, dark green is solds, right? So if we look at last March, we're looking at a lot more new listings than.
Jeff, do you think you can zoom in on that?
Sure. Should be able to. If that's the maximum, that's going to allow me to zoom in on, huh? How's that? Better?
Thank you.
Okay. Anyhow, take a look at what was happening last March. The numbers are a little blurred, but take a look at what's happening. New listings were pretty much peaking last March. Pendings were still well above last March. And look at the available, the ratio between available homes for sale and homes sold. We're actually operating at a little bit above 100% absorption. Now let's come to this March. But what I want you to notice is starting back in November and December, we kind of reached the low point of sales versus homes for sale, new listings. So if you look at the trend lines on pendings and on new listings and on closed sales, you're starting to see a little bit of an uptick. And obviously we're not where we were last year, but you look how we did a deep dive starting probably in about June, went all the way down to a real low point here in probably November, December, closed sales a little bit in January, but we're starting to see an uptick. So that's encouraging to share with your sellers, is that the market activity is picking up. And while there's still a lot more homes open for sale, there's more absorption coming into the market. And let's take a look real quick at Lee. So Lee, a little bit different picture, different market, but look at the median price again, other than condos, pretty steady. Sales down a little bit. Pendings down, new listings up, and still less than Collier, but still a pretty big increase in days on market. So look here, we have a little better absorption, except in condos in Lee, and we have a little less inventory. So it's important to see, what the market is absorbing versus what's being put into the market. And obviously, when we compare to last March, sales are not going to be what they were. Neither are pendings. But overall, when you look at the trend line, and again, we'll zoom this in a little bit. When you look at the trend line, you look, it's even a little bit more dramatic in starting in last year. Probably looks like October, the low point, a little dip in January. But look at what's happening to these numbers. New listings are trending up, pendings are trending up, and sales are trending up. So the market is starting to turn a little bit. And I think it's important that you share that. If you're working with Command, you can share this data. We put it out. You should have gotten a mass email with all of the charts and graphs last Tuesday when we did our sales meeting. So look in your email, you'll have all these charts and graphs. I recommend you share these with your customers. If you're using Command, you can set up a smart plan that's very easy to send this out and become a market expert. Have your sellers waiting for your email each month to see, and your buyers to see what's happening in the market. All right. So one other thing that I'll comment on, and that is the list to sell ratio has gone down quite a bit since last year when that number was 100, 101, and it's gone down quite a bit, which is good for buyers. Sales are going down, inventory is going up, sellers are a little bit more flexible in what they're willing to sell for. Now, I don't see that number crashing. It's been very steady in the 95s and 96s in both markets. Let's see, share. Oh, yeah. But you see 96.5, 96.3. So, I mean, other markets around the country are seeing a much bigger dip in pricing. So the good news is that we're holding firm and have really for a long time in the 95, 96 range. We did climb up to 100, 101, 102 during the peak 22 and 21 and 22. But now there's a little flexibility in the market. So the buyer's like, well, I don't want to pay these high prices. Well, let's take a look, and there is some flexibility. The market has softened slightly. And the other thing that I see when I'm looking at the contracts is I see looking at seller credits. So a lot of sellers are taking a full price offer and giving 10, 15, 20,000 credit to the buyer at closing. So I think we're starting to see a seasonal swing a little bit. We always have had a tendency to show more properties during the season, and the seasonality factor in Collier and Lee, I think we're starting to see as we get toward the end of the season and we start getting a few more sales, we'll start to see these numbers climb up a little bit. So it's still a good thing to share with your buyers and sellers. The absorption's going up. Clearly the absorption's going up. So sellers are going to be able to sell a little faster. Prices 95, 96, still not taking a big dip. And remember to tell your sellers that the market they buy in is the market that they sell in. So even though they may not be getting what their neighbor got last June or July, they're going to pay a little less if they're looking to downsize or move to a different area. So I think the market is showing some signs of promise. Contract wise, I had put on the schedule comparing NABOR to FAR. Unfortunately, I haven't had a chance to update the charts with the new NABOR numbers. We do have a lunch and learn in May with Adam Bludgy, great attorney in town, and I are going to be looking at the differences between FAR and NABOR. And Sam Sod also does a nice seminar taking a look at the differences. So what I want to do is I want to go ahead to next week. Let's talk about listing best practices for listing agents and listing agreements. And one of the things that I want you to know is you can always use the NABOR listing agreement. You do not have to use FAR listing agreement in Lee County. It's primarily a contractual thing. So I want to take a look at the let's take a look at the NABOR listing contract first, then we'll talk a little bit about FAR. And drop that down maybe to. Everybody see that okay? All right, so Mark, feel free to chime in here. So some of the things that you have seen going on in the market and what we're seeing, but in the seller side, always go and get a copy of the warranty deed from Collier Appraiser or LIPA.org and make sure you understand who owns the property. The interesting thing in a listing contract is not all sellers have to be on this contract, but all the sellers have to be on the sales contract. So if a seller was to go out and enter into a listing contract with you as an agent, and there's a brother or a sibling involved, and there's, you know, the sibling says, well, I never entered into that the person that enters into the listing contract with you is agreeing to pay you a commission. And we have had cases where there was a little sibling rivalry, and the one sibling ended up paying the commission. But that's what the seller is agreeing to, and it does not have to be all sellers, although it's really desirable to get everybody on the same page, especially if you have an estate situation or a revocable trust. The broker is always obviously Keller Williams. Well, line 12, line 17 are always on my mind. You want to have an honest conversation with your seller as to what exactly is conveying. And if it's not going to convey, it needs to go down here on line 24. I'm taking my Ring doorbell with me. Okay, let's put the Ring doorbell down here, because the Ring doorbell is generally screwed into the wall and connected to probably your phone. And it's a fixture by definition. So if the seller is going to take that with them, make sure you put that on your exclusions. Now, the other thing that's I think is important is if everything isn't in that list, you don't have to draw a line through it. It's only can convey what's actually there to convey. But if there's audio visual systems, maybe there's an iPad hanging on the wall that runs the lighting and the home automation, that's all got to be conveyed with the closing, and the software that runs the automated home system, that needs to be conveyed if there's a license to it. So be careful you spend time going over what's exactly going to convey with the seller. Obviously, if it's furniture, if it's turnkey, we're going to need an inventory to verify what's conveying, and so that the buyer and seller can agree and there's no drama at closing. I think one of the most stressful phone calls I get is from an agent that hasn't had an inventory. They put furnished on line 12 or turnkey. And then they go there and a lot of the things that the buyer saw when they went to contract aren't there. And you really don't have any leg to stand on. Hey, if you're gonna be a top-notch listing agent, I think it's really important for you to take that inventory and make sure okay, Mark makes a good point there. But anyhow, take an inventory, make sure there's no doubt. There's nothing worse than a dispute over items at the walkthrough inspection and the difficulty in working it out and the hard feelings with buyers and sellers and with our customers. You know, that's your 401k. They have a pleasurable experience. They walk in for the walkthrough, everything's there. There's the garage isn't full of junk and everything goes smooth, and they're likely to do business with you again and also to recommend you. So going back to the seller's comments that Mark added in, if there's a deceased person in there, the closing agent will take care of adjusting the deed prior to the transfer. So if it's in the name of Betty and George Smith and Betty's deceased, it's still the seller's still Betty and George Smith. And then Betty can't sign it because she's not there to sign it. So George will sign it, and then there'll be a death certificate submitted as part of the closing documents, and the title agent will resolve it then. So don't leave a name out if there's an estate situation or a deceased person. Include whatever's on the title in there. Divorces and name changes can be a little problematic. So make sure that the deed might not reflect the divorce. It might not reflect a name change if one of the sellers is recent, if the sellers are recently remarried. So be careful with that and make sure you do your due diligence. And you want to make sure that you try to get that information as accurate as possible. And if there's a question, we always recommend that you reach out to an attorney. Mark?
Yeah, I just had a situation a couple of years ago where someone had been separated, and it turned out that they needed to get the former spouse because it was a homesteaded property at one point, and they needed to get the former spouse to agree, and they had to try and track that former spouse down. They hadn't been in touch like in 10 years. So always good to ask a little bit 3 deep on the questions.
Yeah. The more homework you do filling this out will save you a ton of potential problems as a listing progresses. If I go down to 19, if you take enough classes from me, Broker Jeff hates blanks. I don't like defaulting things, even though if you don't put anything in here, the date the listing was signed becomes the commencement date, and the termination date extends out 270 days from the commencement date if you don't put anything in here. Please don't leave blanks. Just, I don't know whether you've gone over it with your customer and you've agreed to it, or whether you haven't, and there's going to be some surprise. I never signed a 270-day listing agreement. I signed for 3 months. Well, if that line's blank, it's defaulting to 270 days. So put a start date and an end date in there. This time of year is pretty good, but when we switch over from October, November, and December, and the listing expires in March, January, February, and March, oftentimes I'll see that date not advancing for a year. So your listing terminates before it even started. So make sure your dates are good and make sure that they're in there. Interesting thing here that's not really well known is the end of line 21, 22, and 23. And basically, so if your listing goes under contract in April, now let's say today, and it's supposed to expire on April 30th, it's probably not a bad idea to extend that listing with your seller. If you're under contract, they probably have no trouble with it. But it automatically extends to the closing date. And that can be adjusted if the closing date's adjusted. So understand that you do not have to automatically extend get a closing extension signed by the seller. It's always a good practice, but if for some reason you don't get it signed, you're free to move the expiration date out to the closing date. That's something that I get a lot of calls on is, do I have to ask my seller to extend the listing? It's going to expire before we close. So, again, the key here in the property is the proper description, again, coming from the property appraiser's office. There are a few legal descriptions that are bigger than this. You might have to say see attached and attach a separate document. The legal description always trumps the address. Sometimes the post office, especially when you get out on the estates, will assign an address that's a little different. And you want to make sure the legal description is correct and in full here. The PID number comes from the property appraiser, and reserve account balances. Obviously, the reserves are set up by the condominium or by the HOA for specific improvements, replacements of roofs and major components, and anything in those balances that's maintained for that customer automatically transfers at closing. Always put some kind of a price in here. Again, you can take the listing agent agreement over with your customer, but until you put a price in here, you really don't have a deal. So I get them coming through and they're all signed off and the price is blank. Is that an enforceable listing contract? I say probably not. So make sure you have your customer determine this, if at all possible. You're going to give the customer information. You're going to give everything you can and your thoughts on where the market is and where the positioning is. Well, have the seller buy into that decision. You don't want the seller to come back and say, "Wow, you made me sell it for less than I can get." You want that seller to buy into that price, and you want a price there. Can it be changed? Can it be lowered? Sure, but it needs to be in there to have a valid listing agreement. Just a quick comment on MLS 6.0 here, paragraph line 53. So if you check box 1, you are agreeing that you will enter the listing into the MLS within 5 business days. Now we'll talk a little bit about that. If your seller says, I need to do some improvements, or I have some my best friends are coming in to stay for a week, I don't want to, you can have an on MLS date that's different than the commencement date, and your MLS 5 days can track the on MLS date, which we can agree on and put it in the other terms and conditions. So remember that you can have a commencement date, which I always recommend is the date that you sign it. If your customer says, "Yeah, I'm leaving end of April," no, let's not put it on the market till May 1st. Sign the listing agreement today. Have it be effective today. Down in the other terms and conditions, but not to be placed on MLS until May 1st. Cool, no problem. However, what happens if you sign the listing agreement to start May 1st and it's April 17th and your seller bumps into an old friend in the grocery store who says, "Oh, gee, I just got my real estate license. Is there a way I can help you?" And he goes, "Ah, geez, I just signed a listing agreement with Mark Benson, but it's dated May 1st. Well, maybe I can sign one with you today." That would make Mark's listing not too valid. So you don't want to get in, put yourself in that position. You want to have the listing agreement signed the day that you have a meeting in the mines there. Remember that if you check your checkbox 2, you are indicating that this is not to go in the MLS and it cannot be advertised in any way to the public. No sign in the yard, no email blasts, flyers. Can you not put it in the MLS and market it to members of our brokerage or make individual calls to agents and other brokerages? Yes. But the minute it becomes a public event, like even on a social media page, and if you give enough details about that listing, and you're obligated to put it in the MLS in one day, and you know, your fellow colleagues will police that. They see a sign in the yard, look you up in the MLS, it's not there. You got one day, and you know, it's considered a pretty serious offense if you violate that. This was voted in a few years ago when many of the large firms, especially luxury firms, didn't put their listings in the MLS. They put them on their own website and on the consumer websites so that they could track both the buyer and the seller. So the MLS rule came in to try to make sure that if you're going to advertise your listing to the public in any way, that it has to be in the MLS within one business day. Can you put the sign in the yard on Friday, have an open house? Remember, it's business days, so you get one business day. So yes, you could conceivably advertise it and have an open house over the weekend and put it on Monday. So there's a little bit of slack there for you. Always talk to your seller about disclosing information to other brokers when they call. I don't think it's ever a good idea to limit that disclosure, because especially when we ran into a lot of multiple offer situations, giving the potential selling broker information about what is going on with the offers, got better offers for the, and what things the seller was looking for, like a post-closing occupancy, gave the seller really better offers. Mark, what do you discuss with your sellers about disclosure of offers to other brokers that call you? Are you still there? Okay. Anyhow, important to have that discussion. I always say shall disclose the existence of other offers. There's a certain amount of ethical behavior here. In the code of ethics, there is a ethical rule that says if another broker calls you, you must disclose the existence of other offers. So I think that the more you can disclose, you don't have to disclose the price, but the more terms that your seller is comfortable with your disclosing, will get better offers to them in multiple offer situations. On the internet options here, you obviously want to display the property on the internet. You want it to be on the consumer sites where most people begin their searches. You want the address on there. And down in line 67 and 68, the automated estimated valuation model is also called as estimate by Zillow. CoreLogic has one. A lot of different people take all the data in and produce what they think is the estimated valuation range of the property. So we began as an MLS to share with Zillow and Realtor.com and the major websites, all the websites, closed sale information for the last 5 years. The reason we did that was because when Zillow first started out with his estimate, they were horrible. They were 20% accurate, but yet you knew your seller was going online when you're agreeing on a price and saying, well, this estimate is. And I still recommend that you, when you're going on a listing presentation, that you look up and see what you think this estimate is, or what was it for that home or homes in that area, so that when the seller says, I looked on Zillow and here's what Zillow says, you're not uncomfortable about it. You're ready to discuss it with them. But we tried to send information to the portals so that these estimated values would be better and more in line with what's going on in the market. As far as blogging, my thought is I don't like to enable blogging because it's all downside. If 30 people see the house and they post in comments and one or two of them say, that's the ugliest looking master bedroom I've ever seen, that's all downside. So I'm not a fan of blogging. A lot of the sites don't do it anymore, but that's one of the things you might want to go over with your customer. Lock boxes are important. Even if your customer says, look, I'd prefer, you be there for the showings. You still have to ask the question, what happens if I'm over on the other side of town, or I'm not able to get there and somebody really wants to see the house? Can I put a lockbox around the side where it can be accessible, only in extenuating circumstances? But we're operating, for the majority of us, we operate as transaction brokers. So if you leave that blank, I'm not a fan of blanks, but if you're going to operate differently, you need to put that in there. I think Mark operates sometimes as a single agent, so he uses that. But for the majority, I think we want to operate as a transaction broker. You'd like to get the seller's title policy and also their flood policy, because it's very important with a high skyrocketing cost of insurance that you understand that the buyer could potentially assume your flood policy, which could save them a lot of money. So try to get your seller to get that information out. It's probably in a storage locker somewhere, especially if they've lived there for 3 or 4 years. So try to get that information going. Surveys and elevation certificates. Surveys are important. The elevation certificate is somewhat less important because under the new federal FEMA flood system, they've already mapped every property in Florida and every residential property. So they already know what the height is. And, it can be important if there's an error in the data. But other than that, the elevation certificate's not as critical as it used to be. So you want to get as much information from the seller as you possibly can so that you can write an accurate description. Ask the seller, why did you choose this house? What do you think are the most important features? Try to make sure you get as much information you can from the seller. 118 to 120. I would say majority of houses have some form of surveillance in them, whether it's a Ring doorbell or a Ring camera or a camera inside the home. Typically video surveillance, they say the average person is on video 15 to 20 times a day. So video surveillance, the camera on in the home when you're doing a showing, is not so critical as recording. If your seller wants to record conversations that people are having when they go through the house, they really ideally under Florida law should have permission. So I'm not sure that I recommend you have the seller listening in on, but you notice for buyers, we have that little note at the bottom of every one of our MLS reports that says that audio and video surveillance may be in use, so conversations are not considered private. And we used to think that the audio could result in a lot of liability for the seller if the buyer finds out that they were that they were listened in on, when they, that's a good idea. When they were going through the showing, there was a case, apparently, we learned this year, there's a case where a appraiser went to a house and was the sellers recorded the conversation, and the appraiser sued, saying that, you know, he didn't have permission to, he didn't give written permission for his voice to be recorded. And the court said this is a, you know, normal real estate activity, an appraisal or an inspection or a showing, and that the assumption of privacy from an audio standpoint wasn't there. So that softened the risk, I think, we take and sellers take by recording audio. But I still think you want to make sure your seller understands that recording during a showing is kind of a private thing. We got to the habit back when all these devices, when I was an agent, we got in a habit of just saying, look, when we go in here, don't make too many remarks. You know, there's cameras in there. We don't know what they're recording. So please don't say, you know, this is the ugliest bedroom I've ever seen, and start making comments that might affect your negotiations with the seller. So again, I think it's important that you go over that with your seller. If the seller's planning on having these devices on during the showings and the contract negotiations, that you know about it. The next part is compensation, and you know, it's important for you to understand that this line 122 is the total compensation to the broker. So if it's a 6% listing and you're going to co-broke down here on line 136 with 3, this is 6 and this is 3. However, I've had, you know, it doesn't happen that often, but occasionally an agent will put, oh, so we'll split it 6, so this will be 3 and this will be 3. Well, how much do you think you're going to get paid at closing if you co-broke? This much. Your total broker compensation is 3%. You're paying a 3% co-broke. So make sure you understand that, and that you know that this is a total amount coming to the broker. If you're charging the brokerage does not charge a fee, but you might charge a fee to cover your overhead. So it's this percentage plus this fee. The flat fee is only if you agree that you're going to take $10,000 with the seller, that's your total commission, and your co-broke comes down here as half of that, or whatever you want to pay. So make sure the second paragraph is if there's rental involved. So if you're listing a house for sale and someone comes along and offers the seller a great rental, that's your percentage. Okay. This 138 and 139 is an NAR requirement. I see people put different amounts in here, or say I'll pay transaction brokers and single agents, but I won't pay no brokers. So this theoretically, if somebody comes in from another market, not a member of our MLS, and wants to show your home and write a contract, I think you probably should pay them. But when you're entering the listing into the MLS, it gives 3 fields here for each one. And if you put 3% here, 3% here, and no percent there, you're technically saying that someone is not, you know, a member of our MLS or has a no brokerage relationship with their customer, like a for sale by owner or something like that. You know, you don't owe them a commission. So this next paragraph basically says, if I swap it or trade it or move it around between LLCs, whatever my exchange is, other than foreclosure, the broker gets a commission. And interestingly enough, 144 to 149 is there to protect you if your listing were to expire and a buyer who had seen the property during the term of your listing agreement comes and tries to make a deal with the seller after your listing agreement expires. So you can put whatever days in there you want. This paragraph only protects you until the seller lists it with another agent. So 90 days is probably a good rule. I'm not sure that it's happened very often where the seller doesn't relist it and makes a deal with a buyer that saw it while you were under contract with the seller, but that's what that paragraph means. So the seller is interestingly enough, the NABOR contract, the property is located in Lee or Charlotte, the buyer picks and seller pays. So, or they can work a deal, even in Collier, saying seller picks the title agent and pays for title insurance. My observation, if there's a question when you're working with a buyer, is that the buyer is probably always better off controlling the closing. In Lee County, the convention is for the seller to pick and seller to pay, which is fine, except that, remember, the seller's the agent is then, the title agent is then working really for the seller. And municipal lien searches, investigations and all that. I'm assuming you got a good title agent that the seller has picked. Probably not a big deal, but I think there's some subtleties there that give the buyer a certain advantage if the seller, or excuse me, if the buyer is represented by the title company. This is a list of things that are buyer's expenses. I think that you really would do well to use a software program, which you can get on the internet. Our title company has one called TA Access One, whatever it is, to give a seller net sheet. And I recommend you can get on to most of the websites and take a look if it's financing. How much does the seller owe? In many cases, you can enter the date of the mortgage, the date of the sale, date of the mortgage, and the program will calculate the approximate balance on the mortgage. So you're going in there with an idea of Mr. and Mrs. Seller. If you sell for this price, here's what you can expect to net. And I believe, honestly, if you take the time up front to prepare that, obviously you don't know all of the variables, but you can get pretty close to what all the seller's expenses are, including prorating taxes, including stopple fees, that sort of thing. I think broker's compensation. I think it sets you apart as somebody that's really advocating for the seller. If we sell at this price, I'm just giving you an idea of order of magnitude idea of what you will end up with when you finish. The other thing is that the sales contract calls for the seller to convey the property at closing along with any, keys or fobs or passwords, that sort of thing, and to deliver it in broom swept condition. So it's important for your seller to understand that they have to be compliant in delivering the residence in what we call a broom swept condition in the sales contract, or they could be liable for charges for the buyer to clean out the garage or clean the refrigerator out or places. Sellers, especially those that have moved out, have a tendency not to leave it in squeaky clean condition. And if you're taking your walk through with the seller, make sure they understand that all of the stuff in the garage and all the stuff they may have stored somewhere has to be cleaned out. Don't wait for the last minute for them to understand that. Again, taxes are prorated. The day of closing is the buyer, but the seller is responsible for those taxes up to the day of, the day of closing. The seller's disclosure is basically saying that the seller knows of no defects that are not readily observable that could affect the value of the house or the residence, and they're warranting that. A seller does not have to complete a seller's disclosure in the state of Florida, despite the fact that many agents will say, "Where's the seller's disclosure? You're required by law to provide it." You're not. And we have a lot of cases where sellers not live there. It's an investment property. It's an estate situation. So if the seller doesn't know, or it's, there's a widow situation where the widow doesn't know much about the property, I'm not sure it's a good idea to have somebody fill that form out. It's pretty easy to contradict yourself going through there and just saying no, no, no. But really, if the seller doesn't know anything about the property, hasn't lived there, probably not a great idea for them to fill out a disclosure form because of the liability that could accrue to them. If the seller's a foreign person, they need to be diligent in working with a tax advisor and a accountant, lawyer, to make sure they understand what their withholding obligations are going to be. And many foreign sellers had bought 10 or 12 years ago when the market was really low, and they have huge equity built up. So they're going to need to pay taxes on that. And if you're dealing with a foreign seller, I'm sure they all, most of them understand it, but just make sure. An HOA disclosure is by law required. It's a good idea to get that information from the seller. Maybe their most recent association bill is probably the place to get it, but suggest you not look on the MLS to see what other listings are and assume that information is correct, especially with the advent of all these transfer fees. It's not unusual for a community to charge $1,000 up to $7,000 or $8,000 to the buyer as a transfer fee or a capital improvement fee or whatever. Most communities have them from 500 to I don't know, Pelican Bay, I think it's 7,500 or more. Mark, go ahead.
I'm just going to say that, again, getting these numbers up front, it's got to be accurate. If you leave out that there's a transfer fee in the MLS, or you put the wrong quarterly fee for the association, or there's both a condo and a master association fee, and you leave that out, the buyer and the buyer's agent are going to rely on what you put in the MLS. So many of the associations have information available on their public-facing website, but it may also be password protected. So that's a question to ask the seller. Does your association, or do your associations, plural, have password protected websites where they can download the current budget, the most recent year-end financial statement, the application form, because sometimes the application is 100, sometimes it might be 150. So trying to get make a list of all the things that you're going to need, because I think sellers get upset when you come and you ask for one bit of information, and then an hour or 2 hours or 3 days later, you're asking for more information. Try to tell them, these are the things I'm going to need from your association or from your, other information that you have access to.
Yeah, the HOA statute is pretty specific that the information has to be accurate. The name of the association has to be spelled exactly right. And as Mark pointed out, if you have an HOA inside a master HOA, you really need two forms. Even if the HOA is paying the master, you still should have two forms, one for each of the associations. So if those numbers aren't accurate, or if the spelling of the HOA is incorrect, the buyer has the ability to say, I'm triggering a 3-day right of review, which is what the relief to the buyer is, which could be on the day of closing. So I've had cases where the buyer gets buyer's remorse, and the name of the association was not spelled right. What happens is many of these projects are built out over a period of time. So there might be, Eagle Creek 1, Eagle Creek 2, Eagle Creek 9. And they, at some point in time, usually as things go along, they'll combine all those sub HOAs into one. And if you put, Eagle Creek number 9, and it's been combined into an Eagle Creek HOA, that's what happened in this particular case, and the buyer walked. The attorney said, this is a violation of the HOA statute. We're done. There was no discussion. So you have to be careful. I think the best place to get this stuff is from a most recent statement that if the seller doesn't have that information readily available, usually there is a management company or association office on the premises. It's always a good idea to make a trip there to see what's going on, see if there's any assessments, anything upcoming that might affect, a buyer, and you're obligated to disclose that as a listing agent.
Yeah, that assessment thing is an important thing to know.
204 is also very important in that a property cannot be sold or insured, I should say, if there's an outstanding insurance claim. So if you're under your seller's residence or building is under a claim from Ian and it hasn't been satisfied, the buyer will not be able to get an insurance policy. So it's very important that the seller check this, even if you call the association. But if there's an outstanding claim, there's a database that insurers go to that show all the claims that are filed for a particular building and a particular unit owner. And if that hasn't been solved, we've had a couple cases where the closing could not occur until they close that claim. So be careful with that, and be careful that you explain to your seller if we know of any associate, especially with the recent storms, do we know of any claims that are being made or any pending claims that may occur when the insurance settlement occurs and it's not enough to cover the cost that the HOA has to restore the place to normalcy there. So be careful with that. The insurance environment is so bad right now that because of because of the storms, but also because of the legal issues with lawsuits, it's just going to be a difficult couple of years to get the insurance market back in some kind of reasonable condition. But they've been hammered with losses from storms and also from lawsuits. Last year, 71 cents out of every claim dollar paid out in Florida went to an attorney. So we passed some legislation in December that made it much more difficult for a lawyer to sue an insurance company and have the claims assigned by the policy owner. So trying to tighten that up a little bit and hope to get a more normal insurance market in Florida. But that's another subject. The next paragraph has to do with the lead-based paint law. It's a federal law. If the home is built prior to 78, there's a disclosure that is required for the seller to make to the buyer that my home was built before 1978, and I have no knowledge of lead-based paint. Not a lot of lead-based paint issues in Florida, but again, federal law requires that the disclosure be made, that the buyer be given, information about the possible hazards of lead-based paint. And remember, on that agreement, you as the listing agent or selling agent must also sign that form. And I, as a compliance person, I will send it back to you if it's not signed. I'm told that it's a $12,000 fine if they come in to audit your records. And all parties haven't signed the lead-based paint disclosure. So make sure you follow that and get it done. It's not a good thing to have it haphazard and have a potential of fine. Okay. Not sure you're aware of what a CDD is, but so a CDD is where the developer goes in and puts in all the amenities, the sewers, the streets, the street lights, may or may not build a community center, but they'll start building it as they open the community. And what they'll do is they'll go and borrow that money on a bond issue or from long-term investors. A lot of insurance companies and large companies do invest in these developments because they're good long-term investments. So when every unit closes in a CDD, a portion of that debt is assigned to that unit. So if the property is located in a CDD, there's a form that you have to fill out and give to the buyer that says, okay, this is a CDD, it's Pelican Marsh, and here's the balance of my units. Normally, when you buy a unit, the debt that's assigned to your unit is amortized over 15 to 20 years. There's usually a balance, unless it's an older community, that is transferred, will transfer from the seller to the buyer at closing. And a MSTU, Metropolitan Statistical Taxing Unit, is another form of community debt. And you see it, I'm pretty sure that the berm for Pelican Bay is maintained by an MSTU, which is a charge to all property owners of a certain amount to maintain that berm and the roads within the community. So if it's there, where can I find it, Broker Jeff? You can find it on the tax bill. You'll see a non-ad valorem assessment on the tax bill. Now, if there's the words MSTU inside the Collier tax bill, that's not considered an external taxing unit. So I see people send over a CDD MSTU verification for the lighting within a community. No, that's covered by the money you pay to the county covers all the county expenses and special taxing units. The external special taxing unit, like a CDD or an MSTU, will always be shown as a non-ad valorem item on the tax bill. So you can always look at the tax bill and see whether it's there or not. This is an interesting one here, especially in the last couple of years where we were able to bring a seller an offer at or above the list price and the seller turns it down. Theoretically, the seller's failing or refusing to enter into a contract with a ready, willing, and able buyer. So there is an interpretation that the seller shall pay compensation to the broker. Not sure how all that plays out. I have seen it happen, but mainly if the deal falls through, the seller will say, well, let's just put it back on the market. I wasn't comfortable with that deal. It didn't work out. So you rarely would a broker sue a seller for compensation, but it happens. And there's another little twist down here. When a deal falls through by buyer default, the buyer gives their deposit to the seller as a remedy. The broker has a chance to take out their commission up to 50% of those retained deposits. And a lot of sellers will draw a line through that or make it 10% or whatever. But, again, it's unusual for a deal to fall through the deposit goes to the seller, and the broker makes their claim for compensation on there. The contract gives them the right to do that, but in reality, I don't think it doesn't really happen very often. So one of the things that this paragraph C here is if the seller passes away, your listing contract is still binding on the benefit of the parties, heirs, administrators, successors, and assigns. So your listing contract is in force, even if there's a death, or if it's assigned to a in the case of a seller becomes incompetent, signs it over to a successor trustee or a power of attorney. Your listing contract is valid, even though the people that you deal with with regard to the sale of the property have changed, I guess, because of a death or an assignment. All right, so down here in list other terms and conditions, this is where you can put simple statements. The property shall be listed on the MLS on May 1st. The property shall be listed on the MLS when all repairs and professional photography have been taken and the home is staged, or whatever. Make it simple. Don't practice law without a license. If you've got something complicated, let's get some legal advice there as to how to state that. But that's basically the end. Always a good idea to get a contact information so that if there's notices to be sent to the seller, that they can be sent to that address. As far as the broker signature, I'm happy to have you send these contracts to me via .loop or DocuSign, and I'll review them and sign them. However, I'm okay if you sign them, because I'm going to see them when you submit them. So I'm okay if you have a need to sign that and give a copy to the seller at the time the sale is executed. But definitely don't leave it blank. Don't put your listing license name there and leave the authorized broker signature blank, because technically a seller could argue that they don't have a fully executed contract. So I prefer you to sign it and send it to me for compliance or for initials, but you're welcome to send it to me in advance. I'll look it over. I usually can sign them in a half an hour or less. Okay, so that's the end of the NABOR contract. Note that the wire fraud advisory is embedded in all NABOR contracts. There's a separate wire fraud advisory for the Florida Realtors contracts, and we require that as a document when it's not included in the body of the contract. Okay. So know that this is not wire fraud advisory is not a required document when you're submitting a NABOR contract. How are we doing? Do we have any questions, comments? All right, we've got a few more minutes. Let's take a quick look at the bar listing contract. And I'm going to need a couple minutes here, so I'm going to stop sharing.
Jeff,
Yes.
I just wanted to share that if you create the contract in DocuSign and then you have handwritten things on there, I think it's probably a good idea to get the seller to initial the handwritten changes. Or if you left the amount blank and you filled it in when you met with them, probably a good idea to get them to initial anything that you hand wrote on the contract if you typed the rest of it.
Yeah, or if you put a selling price in there and then they change it, it should be initialed. It isn't automatic that a change is made to a contract without being ratified. Good point. I'm going to go here and pull up a bar. I want to do a couple things here. Let me get out of here. Let me go here. Let me go to matrix. Dashboard. Okay. Share. All right, so this is actually form simplicity. I'm just using it as an example. These are all a whole list of Florida forms. But the thing I want to point out to you is there are several different forms for the listing contract in the FARBAR library, right? So you have to understand and use the right format. They have a listing agreement for transaction brokers, single agents, and no brokerage. So the one we normally like to use is the exclusive right of sale listing agreement transaction broker. Mark, I know you operate as a single agent, so you would use that one. But for the most part, we're going to use this transaction broker. And there's also a no brokerage agreement. But I see this is the one, notice that it ends in TB, ERS 18 TB. So make sure you pick the correct sale agreement. There's also another one up here called an exclusive brokerage agreement, right? The exclusive brokerage agreement basically says I have an agreement, I'm the exclusive brokerage representative of the listing, but if the seller brings their own buyer, you don't get paid. So even though it's a valid contract, it's not really permissible in the MLS. The MLS really only wants you to use the exclusive right of sale contract, which gives you exclusivity to represent that seller. And if the seller were to find a buyer, they still have to use you to process the contract, and they still owe you for a so there's a number of different agreements in here. Just make sure you pick the exclusive right of sale listing agreement transaction broker, I think, is the one that we prefer to use. All right. So this is the listing contract from Florida Realtors. Notice that it says ERS 18 TB transaction broker there. So make sure you pick the right form. Occasionally people send me either an exclusive brokerage agreement or one for single agent. So try to use make sure you get the right form. And there's a lot of similarities here. Obviously the seller and the terms, but there is not a inventory.
They don't enumerate the appliances. That's interesting.
Right. So there's not an enumeration of what's going to convey with the sale as there is, and then we mirrored the convey list in the sales contract and the listing contract, so they're the same. And here you get into the sales contract is where you start delineating what will sell at or what will convey at closing. So there's quite a few differences here, and that's one of the things you should know. I have no trouble at all if you want to use the NABOR listing agreement anywhere in Lee County, because it's not convention. I think the NABOR listing agreement's a little bit easier to work with. It's your choice, but I think it's a little easier. Same thing, street address, legal description, personal property, including appliances, okay? You would have to make a list of what those are in order to be, or say, see attached inventory. So make sure you take your time, go over all that with the seller, make a list, have the seller approve it. It will help your relationship during the sale. If the property is occupied by a tenant, we need to know when the lease term expires, because Florida law requires that the tenant's obligations, a new buyer must honor the tenant obligations that are there on the property when it transfers ownership. So you want to know that. Pretty much, again, financing terms, what will the buyer, what will the seller accept? This is the MLS 8.0 discussion about placing the property in the MLS. And down here is where, if you decide not to market the property, 6B1 is checked. Seller does not authorize the broker to display on the MLS. And this is the seller agreeing with their initials to saying they understand that we can't market it to the general public. We can't do any type of advertising. We can't put a sign in the yard. And the seller's initialing that on 65. I see a lot of sellers' initials there when they don't mean anything. Remember, the only time you need a initial there is if the seller is agreeing not to list it on the MLS. Another handy feature of the FAR that I like is there's an asterisk there. And that asterisk says, here, there's somewhere you might want to fill in. So I think is a nice double check when you've written the agreement, go back down there and look at all the lines that have an asterisk next to them and make sure you've included everything that you want to include. A lot of this language is very similar in terms of what the seller's obligations are. Down here is seller certifies and represents sellers knows of no material facts other than the following. So if there's an outstanding insurance claim, if there's a, we had one the other day where we got out of a contract, the seller had gotten paid for a new roof and then decided not to put it on there. So the buyer was struggling to get insurance, and we identified that as a material fact that should have been disclosed. Buyer actually, the seller committed insurance fraud, but we weren't going to go there. We just wanted our money back. You know, when we found out we couldn't get insurance because the seller was paid to replace the roof and decided to pocket the money. Interesting. It's all takes all kinds. Again, compensation is the same kind of thing. This is the total compensation to the broker. Down here is the, in 133 is the co-broke compensation. And obviously you have, the same ability to add information in about if there's a rental there. So this is a brokerage disclosure. It's different in all three contracts. So if you're working with a transaction broker, this is your disclosure of what you'll do for the seller. It's the 7 duties that we provide. And then if it's single agent, then there's a space in there for the single agent definition and also the consent to transition transaction broker. This paragraph is different than in the NABOR contract. You can actually put an amount in there and say, hey, the seller has to reimburse the broker for all direct expenses and pay a cancellation fee. That can be 0, but still under this paragraph, the seller is agreeing to pay on a conditional termination the cost that the broker has expended in the listing so far. And that's a little bit more aggressive than the NABOR contract. Also note that the seller and buyer must initial the bottom of every contract, and then there's several places where the seller and the sales associate and broker have to initial in order to make this contract binding. Initials are not required in the NABOR contract. So down here in additional terms, this is where you would put it on MLS date or time, waiting for time to repair, seller to complete repairs, staging, professional photography. That's all put in there. So again, same thing, seller signature, authorized sales associate or broker. You can sign that, and when you submit it to compliance, I'll take a look at it. If you want me to sign it, send it on. I'm happy to look it over for you, and doesn't take very long. So I think that overall, there's a few traps in this contract in that the personal property is not delineated here. And most people don't put anything in there. They put the street address in and that's it. The interesting thing that I get asked occasionally is if a seller's not happy and wants to get a new agent, the seller can reach out to you as an agent, but you can't reach out to the seller for a property that's under contract. It's a code of ethics violation. So remember that if a seller reaches out to you and says, I'm not happy with my agent and I want to talk to you about marketing my property, you can go and talk with that person. I don't recommend you spend much time denigrating the existing listing agent because it'll backfire on you. But you might say, hey, I can do this. I have, better pictures. I have the national MLS where we circulate all our listings. So, you're advertising what you can do for that seller over and above what's being done now. And you can actually sign a listing agreement with that seller to start on the day, midnight after the other expires. Sometimes you can call the listing agent and say, hey, the seller wants out. I know he's unhappy, but I don't want to lose the money. So you might offer him a referral fee to get the listing a little sooner. But if a seller reaches out to you, you can speak to that seller without any problem. But you can't reach out to a seller that you see their home's been on the market for 189 days and it's not selling. It's not ethical for you to reach out to that seller and say, hey, I'd like to talk to you about a new, listing your property when it expires. So you can't make that call. You can't call on a withdrawal. It's withdrawn in the MLS. It's still under contract with another agent, and you can't make a marketing call. If it's expired or terminated, it's the same. Those are fair game for you to go and talk to the seller and see if you can get the listing. Well, that's about all I got here. It's 3:36. I started a little after 2, so I'm going a little after 3:30. But that gives you a comparison so as to what these listing agreements look like. Use the one you want. Understand that in the area of personal property, this is a little bit less specific. You can still do an inventory and say, see attachment, and you can still have that conversation with the seller to say, what exactly do you expect to convey? That's an important difference between the two contracts. There's a lot of other similarities. Remember, anything that is, all the pages have to be initialed at the bottom. And just as we did in the NABOR contract, any changes need to be initialed. Other than that, they're relatively similar in terms of what they're trying to do. Always use in the FAR bar exclusive right of sale. Don't use an exclusive brokerage agreement because that doesn't give you the right to collect a commission if a buyer comes along via the seller. All right. So I hope you got some value out of today's class. And I'm sorry it was a couple minutes late. tried to attend a class that I was invited to attend, and it ran a little long. But my apologies to you. I hope you had a good day and hope it was informative. And thank you, Mark, for joining us. I always appreciate your input and your insights. So thank you, sir.
Yeah, Jeff, when will you be doing a comparison with the sales contract, NABOR versus NABOR?
I need to update the charts, and I have to do it in order to do this NABOR class. So I committed to have it done by the end of next week. So next Monday, I'll have it updated and have the.
Can you use a NABOR sales contract in Lee County?
Yes, you can use a NABOR contract anywhere in Florida. We see NABOR contracts used up into Bonita and Estero. We don't see too many of them in Fort Myers, but
yeah,
you can use. But the listing contract is no problem at all. You can use that at any time. You want to use the NABOR listing contract, feel free to use that. Like I said, it has a few things to it that are a little, I think, over and above the FAR version, but again, you can use that.
Jerry, you might have to look at the confidential remarks, because some agents in Lee County will say that the seller will only accept a Florida Realtors Bar Association contract.
Yeah, I figured that, because I know we put that in ours, we only want a NABOR contract.
I mean, I can understand a preference, but I wouldn't lose a deal over which form it was on. You know, if I were the listing agent in Lee County and I prefer bar contract, and somebody presented me with a NABOR contract, do I want to go back and say, we're not going to accept your offer and lose the deal over which form it's on? Probably not.
Well,
yeah.
The other thing to answer your question, Jerry, is that if there's a specific requirement in the confidential remarks, that has to be done with a written approval of the seller. Most sellers want an offer. And I had a case where an agent absolutely refused one of our agents from presenting a NABOR contract. And I called the broker, and the seller accepted the NABOR contract about an hour later. So, you know, I mean, if they're saying, hey, you can only submit a FAR as is, or you can only submit that, they really need to have the written approval of the seller. In many cases, the seller's not even aware of it. It's just that the agent is more comfortable with.
Right, exactly. Yeah, I've been using NABOR for 8 years, so I'm comfortable with it.
So I can understand agents in Lee County tend to work more with FAR as is contracts than anything else. So when you present them with something else, they're like, wow. So it's try to work it out. But if your seller's trying to sell their home and somebody sends you a contract that's not in the right format, I don't think you have the right as an agent to say, I'm not presenting that contract. That the law and the code of ethics require that you present it to the seller. I have seen cases where some stuff comes over from Miami and it's not in real good form, and we countered on a NABOR contract for a Marco Island deal. But you can counter, your seller can counter on any format they want. So, but one thing that I am happy about is I'm seeing a lot less as is contracts. Still, Lee County is more as is than not, but we're starting to see some regular FAR contracts float around. And I think that's a great development, both for buyer and seller. So there you go. Thanks, everybody. Have a great afternoon. Appreciate your time, and we'll see you next week.